I, a patent or an electronic device that has a long expired claim. Claim the use of a short and long electrical pulse to perform a specific function. A recent patent also claimed a short and a long pulse to perform the same function, but the claim differed by stating the use of a long pulse and the same short pulse, but one with a specific time of 5 microseconds or less. I'm no expert, but it seems to me that the older patent did not need to claim any pulse times, and this claim should have caused the new patent claim to be rejected. My question is this: should the claim in the second patent that only added the short pulse time have been granted? Would the assignee of the new patent still have a valid complaint based on the existence of the old patent if the method were copied? So there's an old, basically it sounds like an expired patent that's talking about, hey, long pulse and a short pulse. Generic, they were the first, they were the grandfathers, so they sort of had that nice broad protection, broad rights, exclusionary rights. And a second patent came in and was issued, and with a much narrower scope regarding the second one being specifically 5 milliseconds, I think it was, or less.
Yeah, something like that.
Very short amount of time. So a couple of things you would have to really answer this. You'd have to look at what's called the prosecution history. It will see if the examiner, and this is public information inside public, it's not called the patent center. Go see what happened. What did the examiner cite that expired patent that you're talking about? It's likely they did. You hope they did, if it's that so close. And there was probably some back and forth. And my guess would be that the patent owner, and maybe if they had an attorney, was able to successfully argue that it was not an obvious amount. There's something where a pulse, the second pulse was in industry or common to be much longer, and nobody's doing 5 milliseconds or less, or it isn't even achievable, right? And so somehow producing evidence that it was not an obvious way of administering a second pulse. That's kind of all I got.
Yeah, I'm wondering maybe if the application's completely different, right? Same technology, but different use case, right? And they're using it in a different way for a different purpose, but similar technology. I suppose that could potentially.
I think so. Yeah, right. Yeah, like one's for laser hair removal, one is for a sensor, for detecting, image detection. Great, Matt. I think that's probably right. Good point.
That's the way I'm thinking about it. Is like maybe there's some use case here that's not lining up exactly, right?
That's what the chat's got. Gosh, look at chat go crazy here. Here's the summary. I'm going to read the summary. The newer claim might be valid, but only if the 5 microsecond limitation adds something non-obvious. Yes. The assignee of the new patent cannot stop someone from practicing what was already disclosed in the old patent. If the claims cover methods fully disclosed earlier, they may be vulnerable to invalidity arguments. Look at that. Yep. Well, I like your answer too, Matt, but I'm super happy that they came back and mentioned non-obviousness. And it was sort of on the assumption that we're talking same technology. There may not be that obviousness requirement. Say we're talking about different apples and oranges.
Mm-hmm.
Great question. That was fun.
That was good.